Welcome back to Prism Break. It's been a month since we had an opportunity to come before you, but we are excited about this new episode. Today, we're going to be talking about the switch to race-neutral programs. And I am excited and that we have a wonderful guest to join me today to talk about this very, very important topic, Mr. Franklin Lee with Tidings and Rosenberg. And I'm going to give Franklin a chance to introduce himself. We have a long history together in the work that we've done in the industry. But before we get started with that, Franklin, just tell the audience a little bit about yourself.
Well, first of all, thank you, Donna, for having me. It's always a pleasure whenever I'm working alongside you in this field. My background, as you know, I started out as an antitrust lawyer with the Federal Trade Commission quite a few years ago. That's where I got my background in economics and understanding markets as an antitrust lawyer. And then I became chief counsel of a nonprofit organization founded by late Maryland Congressman Perrin Mitchell called the Minority Business Enterprise Legal Defense and Education Fund. And I served in that capacity for 16 years in the front lines and the battles on economic inclusion, Supreme Court cases and the whole 9 yards. After that, I went into private practice. I said, oh, it's time for me to try to make a little bit of money before I get up out of here. So I went to a couple of different law firms, and now I'm with Tidings and Rosenberg. So I've been serving as a civil rights lawyer and a partner in Tidings and Rosenberg for about the last 16 or 17 years now.
Wonderful. So as you know, just about 100 days ago, we have a newly elected president, and the impact of that election and the executive orders that have come forward are having a dramatic effect on the small business programs around the country. But before we get into the executive orders, I want to just talk about and explain to our audience exactly what are race-conscious programs, what are race-neutral programs, and how did they even come about that we even needed them. You talked about your history, right, and what Perrin Mitchell brought forward over 40 years ago was the small business participation, that governments needed to include small business at a 10% level. And of course, we know small businesses have continued to expand, but somehow that still is the goal. But talk a little bit about the history of how that was enacted. I know that was a small business program, but ultimately that matured to minority-owned and race-conscious programs.
Well, actually, Donna, we only have a certain amount of time here today. I could go all the way back to 1865, 40 acres and a mule, and the Freedmen's Bureau Act that never got funded. But let's just stick with the last century. As many folks know, the civil rights struggle and trying to establish equal rights under law has been a long and arduous road. And in the 1960s, we had the first Civil Rights Act enacted to try to provide equal opportunity. There's another law called, Section 18, going back to 1866, the Civil Rights Act of 1866, which made for equal rights on the basis of race in the making and enforcement of contracts. But the first affirmative action, that is, positive efforts, intentional efforts to try to correct and remedy the effects of discrimination in the marketplace, really came about with Perrin Mitchell's signature law called the Public Works Employment Act of 1976. There was a big recession, and there was a stimulus bill to try to restart the economy during the Nixon administration. And Perrin Mitchell was astute enough to get a rider put on that legislation to actually set aside 10% of the contract dollars for black contractors. And a number of them got their start working on the Alaskan pipeline.
So it was for black contractors,
It
not
was for black contractors,
Okay.
just limited to that. It immediately got attacked as being unconstitutional in a case called Fully Love versus Klutznick that went all the way up to the Supreme Court. We had a different Supreme Court back in those days, and they actually upheld the constitutionality of that program. Fast forward to 1989, when other state and local governments began replicating this notion of having minority and women business programs, having goals, typically 10% of contract awards that they tried to target for minority and women-owned businesses. That got attacked in a case called J. Croson versus City of Richmond. That too went all the way up to the Supreme Court. It was a different Supreme Court by then. And the Supreme Court at that time said anytime you use what's called a race-conscious remedy, you use a racial classification in state or local government law, the courts are going to impose what's called strict scrutiny in order to analyze the constitutionality of that. We have something under the 14th Amendment of our Constitution called the Equal Protection Clause. That means that any human being basically should be treated the same under the law on the basis of their race. So that standard was invoked. It's called a strict scrutiny standard, where the courts had this heightened scrutiny of any racial classification, even if it was was intended for good means of remedying discrimination. So out of that case, the disparity study industry was born. State and local governments around the country were required to have a strong basis in evidence to support the use of any racial classification in their programs. So a race-neutral program, on the other hand, is any type of policy, any type of program, any type of regulation that does not use racial classifications. So a small business program, which we've had in this country since 1958, where we've set aside contracts for small businesses, that's based on size. It's not based on race.
Right. So based on revenue, based on number of employees, factors that are not imposed
have nothing
by
to do
race
with
or
race.
gender.
But keep in mind, even though that happened in 1958, we've had those kind of set-asides for small businesses since 1958, and they haven't really been challenged or threatened in a Supreme Court. The Public Works Employment Act of 1976 found that only 1 to 2% of all federal contract dollars were going to black contractors and vendors. And so the ongoing effects of that past discrimination were adversely impacting market outcomes.
So I just want to insert a point real quick, because the reason why it's showing that it's discriminatory is that the availability of firms existed. So in other words, it's 1%, but there were more than 1% of the firms available to actually service those contracts.
That is correct. So what's kind of emerged from the jurisprudence from all of these court cases is an understanding that if what's called statistically significant disparities exist between availability and the actual utilization in dollars awarded or dollars paid to firms on the basis of race, that creates an inference of discrimination. It's something, I won't get too much into the details, but it's called two standard deviations. If you've got like a 20% disparity.
Taking me back to my calculus.
Yeah, we're going back all the way back. But if there's a significant disparity, statistically significant disparity, that creates this inference of discrimination.
Right.
And that starts the beginning of the analysis as to whether factors other than race and gender are causing that disparity, or whether race is having an impact.
So these disparity studies, it's important to note that significant research is going into them. They're examining the availability of firms in the market by industry. They're looking at the contracts that are being awarded and the dollars being spent. And they're analyzing whether or not there are also practices that exist in those organizations that contribute to the fact that these businesses aren't being given the same opportunities and aren't yielding the same types of contract awards. So this is not something that is made up. These cities, these states, they're spending significant dollars to document that the discrimination exists, and then that basically circles back to the laws of in 1865, 1866 that established that the federal government would not discriminate. Is that the
Well, yeah.
circle?
I mean, there's laws like Title VI to say the federal government has to make sure that its dollars are not being spent in a discriminatory fashion, that all people have access to participate in those programs. But you know, the real central thing to understand is, I kind of describe it this way. Your disparity studies are basically like a battery of tests to try to diagnose what the problem is. We know there's a 95% chance that something's wrong if you got a 20% or larger disparity between availability and utilization. So then the rest of the disparity study is a battery test to try to figure out, well, where are the barriers? What's causing this? There are such things as race-neutral barriers. Maybe a firm is just too small to bid on a large contract, for example.
Right.
It's got nothing to, may have nothing to do with race. On the other hand, they may be small because they can't get access to credit the same as their white competitors.
Sure.
And that can limit their capacity. So what we're trying to do with these studies is really diagnose the problem and then come up with narrowly tailored remedies to address the problem. If you've got a race-neutral problem, for example, experience requirements. I've seen this a lot with state and local governments. They got experience requirements that lock out non-incumbent firms. And it just so happens most minority businesses, more of them will be non-incumbents than others.
So another example of one of those race-neutral barriers could be the bonding requirement that is established. And most folks don't think about it as a barrier until you understand what's required to get bonding. And when I encountered a project as a prime, one of the first times in the city, put a bonding requirement, I said, oh, no big deal. I'll go get bond. What's the big deal? And that's when I realized what was required to get bonding. You either had to have significant capital available.
Gotta have that liquid
right. It was like, whoa, who has that kind of money? You know, it was a $5 million bond. Or you could pledge some sort of collateral, like your home. And so what it made me realize is that for many diverse business owners, if they're just getting started, number one, they're not going to have the liquid capital. But number two, in the communities for minorities, a lot of them still are renters. Many of them are first generation home buyers. And so they wouldn't even actually have the equity in a home to even support a bond.
And then you've got the problem with discrimination in housing markets adversely affecting the appreciation of equity.
So all of those things combined contribute to the fact that if you can't get bonding, then really it's automatically an inhibitor to just participating in access to those contracts. Okay, so let's fast forward. The research is done, and cities and states institute programs for minority business inclusion, for woman-owned business inclusion, and these are meant to remedy the discrimination. But I believe coupled with that, in most cases, a city or state will also have a race-neutral program.
Yes, and actually, I would say over the last 15 years where I've been providing counsel to state and local governments on threading the needle with strict scrutiny in developing programs that are not only legally defensible, but also effective in overcoming the disparities in the marketplace and the effects of the discrimination. I've focused on what I call a hybrid model that combines both race and gender neutral elements and race and gender conscious elements. For example, you may have certain tools that will be put into your ordinance or your policy where you can set aside prime contracts for small businesses. That's a race-neutral type remedy. Or small local businesses that tend to be, they just happen to be a higher concentration of minority-owned firms in that category. You can be more aggressive at the prime contract level with race-neutral remedies. On the flip side of the coin, though, I will also put elements into that toolbox or into that medicine cabinet, as it were, in terms of remedies that are race conscious that can be applied on a contract-specific basis when the facts indicate that that's warranted. Let me give you one example of that. I was working with one of my clients down in Florida that had pre-qualification requirements for engineering firms. And so there was no question as to the qualifications of the firms that they pre-qualified. There were 6 black pre-qualified engineering firms that were put in this pool of firms to get task orders for engineering. Over the course of 5 years that were included in a disparity study, not a single one of those black engineering firms got 1 dime worth of business out of that county. And there was no explanation for that. You know, the disparity study consultant went and asked the heads of the agency, well, do you know why this has happened? These are all pre-qualified engineering firms. Didn't have an answer for it. So we developed a remedy that we put into the policy. This is some medicine they can put in their cabinet, in a medicine cabinet, that says if you've got a minority firm that has not gotten business before from this county, and there's a rotation of contracts, you can put them in a rotation where they will get an opportunity to perform contracts of a certain size.
Sure.
Or we can have what's called evaluation credits, evaluation preferences. For that category of firms that's been discriminated against and locked out of contract opportunities, when they're competing for future contracts, they'll get an extra 5 or 10 points added to the score of those people that are on the evaluation panel to determine who they're going to select.
Okay. And when that was introduced, did they see a change in the participation? Did it naturally then begin to occur? Because that's what we're trying to achieve. We're trying to achieve natural inclusion through the programs. We're trying to influence practices where biases normally kick in and promote exclusion. We're trying to promote where those opportunities, because the firms are qualified, they have the experience, and they just haven't had the opportunity.
Right, and so what we do there is we actually build into the policy itself periodic evaluation to see how well the different remedies are working. Is the race-neutral small business goal helping to correct those racial disparities? If not, how is this evaluation preference in favor of minority businesses working?
Got
it. And that has to be reported periodically. It also informs how aggressive you need to be next year in terms of the mix of race-neutral and race-conscious remedies that are being applied to the marketplace.
Great. Okay, so I think we have a clear understanding of how the minority businesses and the woman-owned business enterprise programs have come about. We understand how the small business programs are coming about, and as we said, they've been in place many years. There are lots of opportunities to create unique ways to be inclusive of small businesses, which are intended to be inclusive of all businesses. And so what I want to talk about next is the impact of some of the legislation that is coming about in cities, states, even at the federal level. So Early Warning Software is the manufacturer of socially conscious software. And PRISM Compliance Management just happens to be one of those softwares. It's an all-inclusive platform that allows customers to collect that data necessary to be able to know whether they have support for a small race-neutral program as well as minority and woman-owned business conscious programs. And so this episode of Prism Break is sponsored by PRISM Compliance Management.
This episode of Prism Break is powered by Prism Compliance Management, the go-to resource for organizations looking to navigate small business compliance. If you're ready to achieve more, Prism Compliance Management provides the tools, insights, and strategies you need to succeed. Visit prismcompliance.com to learn more.
Welcome back to Prism Break. So Franklin, it's been, as I mentioned earlier, an interesting few months. And one of the things that has occurred with the executive orders that have come about from the administration, it's almost been a series of knee-jerk reactions from cities. I don't know if it's at the state level, but definitely from at a local level. And so I had an opportunity to meet with a few city and county leaders this past month. And one of the things I wanted to help them understand is what is the difference between an executive order and law. And so I introduced the fact that executive orders are meant to impact the operations of federal government versus constitutional, state law, and local laws. They are actually meant for the operations of those individual, whether it's local, state. And so, in essence, no pun intended, but these state and local laws could actually trump executive orders. So say a little more about that, because it was unnerving for me to see county and city managers not understand that distinction.
Yes, that's because when somebody acts like a king, a lot of people just fall into the role of being loyal subjects. But we live in a democracy still, at least last time I checked, and the rule of law. And under the rule of law, no presidential executive order can overturn a statute that was enacted by Congress. We have three branches of government: the executive branch, that's where the president is. We have a legislative branch, Congress, the House and the Senate, and we have a judicial branch. And these three branches are designed under our Constitution to provide checks and balances on one another to preserve a rule of law so that everybody gets treated the same. This particular administration has gone into hyperdrive in terms of issuing executive orders, and some of them have been amended over time to kind of make them more ambiguous, and people aren't aware of that.
Sure.
What we're most concerned about, obviously, is the anti-DEI or diversity, equity, and inclusion executive orders, followed up by a series of memoranda that have come down from the Justice Department and elsewhere to try to implement those executive orders. But they're drafted in such a way, these executive orders are drafted in such a way to give the impression that somehow DEI is just unlawful. But actually, the executive orders say we are seeking to eliminate waste, fraud, and abuse, and we're seeking to prevent the government from implementing DEI in an unlawful manner. So what does that mean? It doesn't change any of the statutes that have already been enacted by Congress. These executive orders do not change the court rulings about those executive orders. So the Croson case is still good law, Adirondack is still good law, and we have a number of other decisions around the country where race-conscious programs have actually been upheld as being constitutional based on a strong basis in evidence. So we need to make that clear up front. These executive orders, in my humble opinion, are designed to intimidate and to scare people into running for the hills. And indeed, a lot of people, a lot of entities, a lot of organizations, unfortunately, are doing that without any analysis of what's legal, what's proper, what's necessary under the circumstances.
And that's unfortunate for two reasons. One, because of the impact that it can have on the programs that are in place to remedy the very things we talked about earlier. But the second reason is it's going to stall progressive achievements that were already in place to show that cities and states were actually doing the things to be inclusive and actually follow the laws that they have in place. So are they, in fact, by halting these activities, putting themselves in a position where lawsuits could be filed against them for not following their
Yeah.
own laws?
Donna, here's the thing. A lot of people don't understand this. You can be sued at any time by anybody for anything. And this era of executive orders hasn't really changed anything in that regard. You can be sued with an executive order, without an executive order. The issue is, will you win or can you defend yourself if you get sued? And so what we're seeing is a lot of folks just retrenching back in sort of a knee-jerk reaction to these executive orders because they don't want to become a target. They don't want to become an easy target. And that's understandable. But my position is, if you design your program properly and you have the right evidence or factual predicate to support why you've designed the program the way that you have, then you've got a decision to make. Do you want to be fair, or do you consider fairness a four-letter word in this day and age? When did equity become a four-letter word? That's kind of at the foundation of our entire system of jurisprudence in America since its inception. Now we're being told, well, if you are inclusive, that's bad. When actually Jim Crow was exclusion on the basis of race, and the 14th Amendment supposedly overturned that.
Sure.
So don't overreact, because if you overreact to the current climate, what's going to happen is you can end up getting sued by others that you don't anticipate getting sued by, that no longer have equal access to the marketplace, no longer have a remedy for the discrimination that either a local government or its contractors have imposed upon them. So do the right thing is my mantra. Do the right thing. Make sure your policy is legally defensible and it's effective, and that you have the data that you need to support it.
So that is an excellent point. One of the things that we're helping customers with as they explore the merits of their programs, many of them actually have disparity studies that support the basis of them having woman-owned and minority-owned business program, and even following the disadvantaged business enterprise programs. So they have those elements in place. Fortunately, many of them are using our systems to still collect the data that's necessary. And that's one of the things that I emphasize with leaders, is that you must have the data to support, even going forward. Even if you have a disparity study done, don't stop collecting the information. And in today's climate, I think is equally as important as we talk about race-neutral programs, is that they have the data to understand not just race-based data, but also gender-based data, but data on the factors that actually show that businesses are inhibited, like income, like access to opportunities, right? Like capacity. Those are factors that are, as we mentioned before, they're race neutral. And so there are ways that customers can institute small business programs, and these small business programs can be based on locale, income, capacity, zip codes, and they can still address and create opportunities without being challenged.
You're so right, Donna. It's so important that careful analysis is done to identify what kind of barriers these firms are dealing with, getting into business, growing, and then competing successfully for contracts.
Okay, so I want to talk about next a little more of the lawsuits that are at hand. So the activity in the industry has prompted a number of actions that are brought forward to address the executive orders. So we see some lawsuits that have come about. Share with me a little bit about what you know about what's going on in North Carolina, because it's actually halted some activities that we thought were going to be proactive, and it seems that there's some retraction. What's going on
Yeah,
there?
Donna, I was just down in Raleigh, North Carolina recently, and it's like deja vu all over again. We went through this after the Croson decision back in 1989, and it's happening once again. They used to have a minority women business program in North Carolina back in the 90s. And after the Croson case, it got changed to what they called a hub program, which was historically underutilized businesses. Now that's being challenged by state legislation or bills that have been introduced into the state legislature down there. Patterned after the Trump anti-DEI executive orders, actually, just giving the clear impression that this is unlawful and we won't permit this in the state anymore. Hasn't been enacted yet, but it's been proposed. And then the other strategy that we see being used down there is to just simply defund the administration of the hub office statewide. So there's a lot of misinformation being put out there about what the hub program does, what it doesn't do, and forces are beginning to come together to correct that misinformation. But again, you got to look at what are the barriers, where are they, and how do you remedy them? How do you address them? Using race-neutral measures first? Does that make sense? Or do you use a stronger race-conscious remedy in order to address the various forms of discrimination that may have been identified?
But if people are rolling the hub programs back, isn't that saying that they don't care whether there exists discrimination? I think that's what many business owners feel.
Well,
Is that if you're going to roll the program back, you're saying then you don't care. That's what the legislators are saying.
That's a very good point. In fact, all of the policies and ordinances that I've drafted in the last 15 years or so include what I call a commercial non-discrimination policy. It's race neutral. It says that we, the government, have a compelling interest to make sure that our tax dollars are not financing the evil of private prejudice. And that's not Franklin Lee's wording. That came straight out of the Supreme Court in the Croson case, actually. So if government is willing to go ahead and award contracts to prime contractors that say we don't want to take any bids from any minority firms because we don't have to and we can do what we want, we're not going to be inclusive, to heck with you. If that's their attitude and they're excluding on the basis of race, they're violating that commercial non-discrimination policy, and that's a race-neutral policy. But if governments don't want to enforce a commercial non-discrimination policy like that, they're really saying we don't care whether we help these discriminating prime contractors lock out minority firms.
That's exactly right. So that's actually, I think, more of a scary, if you will, as a business owner, reality. If that's something that will come about, that could substantially impact women and minority-owned businesses' participation. So even if we do have race-neutral programs, things like that could actually really then be a big setback. I think one of the things that I wanted to bring up, I was at a conference recently, and many folks, the buzz is just, why is this even coming about? Why is there an issue all of a sudden with the programs that are meant to be inclusive, right? I recently reviewed a state's participation, and they have availability of 9% Black-owned businesses, and they're doing 0.8% business with them, right? And so at the conference, people were saying, well, the reason why this is happening is because Black people are doing so well. They're succeeding too well. And when I looked at the numbers, I said, well, when I look
Fake news,
it-
fake
it-
news.
right, how do you define success in all of this? The other statistic, so if black people were getting 0.8 8% of the business, and there's 9% availability. So I just had to go and do the math on white. So white women and white men were getting 92% of the business, and they only reflect 62% of the availability.
And those
So,
same numbers I was hearing in North Carolina last week, by the way.
okay, so
It's not an isolated experience that you've had.
So I think without needing to do a disparity study, although both of these states have done them, clearly it shows that the practices for making sure that our taxpayer dollars are being applied and given access to all people, it's not happening naturally, and that the woman-owned and minority-owned business programs are intended to remedy
And
those
you have to be intentional about a remedy. It's just like if you go to the doctor, you got a bad headache, he does a CAT scan, does an examination, look at your family history and all of that. Says, well, you got brain tumors in your family, you got cancer in your family. Let's see if that's what it is.
Yeah.
If that doctor turns around and just prescribes some Tylenol, that's malpractice.
Mm-hmm.
You're going to have to come up with a more aggressive remedy than that. Disparity studies are supposed to be the same way, and the remedies that we have in these programs should be tailored to address the findings of those studies.
So one of the things that we have introduced, and we're innovators. So we didn't stay in business for 31 years not adapting to the times. This is one of those occasions where we have to adapt to the times, and our customers have to adapt to the times. So how do we position them, right, in these times with the climate? Number one, we've talked about educating their legal teams that executive orders do not override state and local law. I think that's very important. And that's one of the elements that was called out at the conference that we went to. I think the other thing is to be exceptional in implementing small business programs, right? Leverage those race-neutral programs in such a way that they can be inclusive. Now, one of our states and our customers is about to introduce 2 new race-neutral programs, which I'm excited about. And I'm not going to give it away. I'll talk about it in our next episode. But I'm really excited about what they're introducing. And then thirdly, you must have the data in order to have highly effective small business race-neutral programs. So I want to make sure that customers understand whether you're using PRISM Compliance Management or some other tool that is less innovative. You must collect data on your small business's income. You must collect the data on their capacity to participate, their number of employees, their location, all these new race-neutral measures. And then I should say new. For some people, then they may be new. But you cannot just label them as minority-owned or woman-owned anymore. So we want to make sure that our clients are collecting that depth of data so that then they can introduce small business and race-neutral programs like micro-business programs, right, where you could actually set aside contracts by a certain dollar threshold that are open to micro small business.
Some of them are called emerging small business programs.
Right, and some customers
Newer
have
firms, smaller firms.
sheltered market, right? So there are
And
lots
it's
of
entirely
opportunities.
permissible.
And I wish we had more time, but I know, Franklin, I want to thank you for coming today. I know we're going to be able to have you back again at some point. So thanks again.
Anytime, Donna.
Okay, I so appreciate it. This episode of Prism Break is sponsored by Early Morning Software. manufacturer of socially conscious software. Prism Compliance Management is the go-to source for organizations looking to navigate small business compliance. If you're ready to achieve more, Prism Compliance Management provides the tools, insights, strategies, and data that you need to succeed. Visit prismcompliance.com to learn more. Thank you for watching Prism Break. Please follow us on our podcast channels, Apple Podcasts, Spotify, and YouTube. And follow us on our social media handles for Prism Compliance Management.